Welcome to the Coimbra Law Firm podcast, and today we're going to be looking at something that I've had a lot of people ask me questions about over the years. Imagine you're going about your daily life, your career, your relationships, whatever it might be. You are in the throes of dealing with life, with all the curveballs it throws at you, and then out of the blue, you receive a letter from a district attorney, a prosecutor, a city attorney, what have you, and someone is accusing you of a crime. The only problem is you barely have any memory of the alleged conduct. It might be something that happened years, maybe even decades ago, and you're kind of scratching your head and you're asking yourself, how is it possible that someone can specifically a prosecutor can file a claim against you or charge against you in criminal court? And mind you, we're not talking about a civil case here where you pay out some money and you move on with your life. We're talking about something that can result in the loss of your freedom. And this conduct is being attributed to you that's criminal, whether it's a sex offense or a theft offense or a violent crime, a violation of any of the myriad statutes in the California or sections of the California Penal Code. There has to be, or you would think there has to be, some mechanism that limits that, right? There's got to be some sort of limit to accountability, especially in the sense that something can just reach out of the past and grab a hold of you and causes you to end up in a jail cell. Anyway, to a certain extent, the law is equipped, or the penal code is equipped to handle those situations, and there are so many exceptions that alone merits its own separate discussion, and we're going to try to discuss both the statute of limitations for crimes in California, as well as all of the various exceptions within the time frame that we have here. The statute of limitations, what is that exactly? The statute of limitations specifies a period of time within which a prosecutor can bring a case against you. And mind you, there are crimes for which there is no statute of limitations at all. So if you committed the crime in your adolescent years, you are now in your middle or even senior years, there's nothing to stop the prosecutor from filing a criminal case against you. These, of course, are very limited. We're talking about offenses for which you can be punished by death, life in prison without the possibility of parole. So, murder, for example, would be the most obvious example. Believe it or not, embezzling public funds has no statute of limitations. Or cases where the defendant is a minor and the prosecutor can request what's called a fitness hearing under the Welfare and Institutions Code. So these are, obviously the scope is pretty limited here. Most crimes do carry a statute of limitations, but we're going to get into some of the scary exceptions where the statute of limitations doesn't apply. So really, in practice, the scope of crimes where you can be prosecuted years or even decades later is actually a lot longer. The list is a lot longer than the penal code would have us believe. Anyway, we're going to try to get through some specific crimes here, so that you kind of have an idea, because there's no really one size fits all. There are various crimes with different statutes of limitations. So, for example, if you're being accused of a crime where you could have gone to prison, or you can go to prison for 8 years or longer, and there are a host of such crimes. Generally, the statute of limitations is 6 years. If you are being accused of having committed a crime against a dependent adult or an elder, with the exception of embezzlement or theft, then the prosecutor has to bring the case against you within 5 years from the date of the offense. So if it's 5 years and 1 day, your lawyer can obviously try to get the case totally thrown out, because now we're dealing with with something that violates the statute of limitations, because it's being brought just way too much longer than the statute allows. Now we're going to go into some of the crimes where the statute of limitations is a lot longer. For example, offenses that involve producing pornographic material with a minor, that's 10 years. So the prosecutor can bring a criminal case against you up to 10 years later. Failure to register as a sex offender carries the same time limitation. As far as misdemeanors go, we're talking DUI offenses, petty theft, things of that nature. You're looking at 1 year. They've got to bring the case against you within a year after the date of the offense. There are specific crimes that if you commit upon a minor under the age of 14, it's a 3-year statute of limitation. If you're a doctor or a therapist and you have committed a sex offense with a patient, it's a 2-year statute of limitations. And then various offenses involving fraud, involving breach of some fiduciary obligation, or embezzling or committing theft on an elder person, or some sort of, like, if you're a politician or councilman and you commit some sort of misconduct in office, you're looking at a 4-year statute of limitations from the time of the offense or when it's discovered. Now we're going to get into the more interesting area of statute of limitations, which has to do with what's called tolling. 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 What does that mean? When the statute of limitation gets tolled, it means that there's something that stops the clock from ticking. So if you think of a statute of limitations as a clock, and that essentially the prosecutor has to bring a case against you according to the schedule of that clock. There are exceptions which can stop that hand from moving, which does not bode well for you if you're a criminal defendant, because that means that even more time can go by within which the prosecutor can file a criminal case against you. So we're going to look at the reasons for why or how that would happen. So, for example, with certain felony sex offenses against a victim that is under the age of 18 can be brought against you basically at any time before the victim turns 28 years of age, or within a period of 10 years after the offense was committed. And you'll see that a lot of these have to do with sex offenses, with sex crimes. Let's look at some other ones. For a sex crime against a victim who was younger than 18 years old and the statute of limitations already ran out, but this person filed a police report, then essentially what happens is the statute gets extended for another year, and then as long as the prosecutor starts the case within that year, it doesn't matter that the case happened a really long time ago. It's essentially like a saving grace for the criminal case. And of course, there has to be some kind of independent corroborating evidence that is going to be admissible in court. It can't just be some verbal accusation without anything to back it up. Something has to substantiate it that is both admissible and independently corroborating. The next one is a sex charge or a rape offense can be filed within a year of the date when DNA is utilized to find out or to discover the identity of the suspect. So that, of course, with DNA evidence, the legislature and the courts have found that the reliability of that is so high that the risk of a wrongful accusation coming about through a very late filing is diminished, because mitochondrial DNA can establish the identity of the perpetrator. So that extends it. If you are out of state and the the prosecutor's trying to file a criminal charge against you where it would otherwise be like a year, for example, like a misdemeanor crime, the statute of limitations is going to be told, meaning it's going to stop, and they can bring the charge against you even after a year, but it can't be more than 3 years. And then there are also certain crimes having to do with licensing violations under the Business and Professions Code, also for contractors. And these have specified statute of limitations going up to all the way up to 4 years. So as you can see, there are a variety of statutes of limitations that apply for different crimes. If there's any area of California criminal law where there is no one-size-fits-all rule, it is statutes of limitations. They're very difficult and complicated. There are exceptions to the exceptions, and if you've got a really good attorney, you're being prosecuted or investigated for a crime, and you're scratching your head and you're like, God, I didn't even do that. How is it possible that not only are they bringing a charge against me, but I'm supposed to defend myself against something that happened, a decade ago? This is ridiculous. Well, you need to consult a lawyer who knows what he's doing with respect to challenging a criminal filing that's being brought that late in the game. There are other issues. There are due process issues, even where the statute of limitations has not run out. Even if they're filing it within the time period, you can file, or your lawyer can file, something that's called a CERNA motion, where you're arguing that there are diminished memories, there are witnesses who are no longer available, and that you're going to be prejudiced as a result of having to defend yourself against an accusation that occurred a long time ago. There are due process claims that you can make. So there are ample ways to fight against a criminal accusation for something that happened a long time ago, but you can't just raise your hand and say, hey, this happened so long ago that it's not fair. It has to be rooted in the case law. It has to be, you've got to have a skilled lawyer who's successfully made these challenges in the past. And the great thing about making a statute of limitations or due process argument is that you're essentially, and I hate to use this this idiom, but you're essentially killing the baby in the crib. You're nipping it in the bud. You're not. This is you're essentially strangling a really bad situation, or you're getting rid of it before it metastasizes or avalanches into something that is, where defending yourself is going to be really difficult. Because imagine if you're being accused of something and you don't have a good lawyer, or maybe you're using a public defender who's just overwhelmed with cases, or you have somebody who practices criminal law every now and then, but generally does immigration law or civil law or whatever, doesn't know the mechanics of statute of limitations. Now you basically exhausted. You didn't exhaust. You gave up. You forfeited a really great opportunity to get rid of a case on a technical ground, on a technicality like a statute of limitations, and now you're having to fight off a case, maybe at trial, and your exhibits are coming in, and the jury's looking at it, and they're, giving you the stink eye, and it looks like they're going to convict you. Why go through all that hell? Why go through months, potentially even years of, going in and out of court, when you can have an attorney who knows what he's doing, who knows how the statute of limitations works, and all the exceptions and the exceptions of the exceptions, to kill off the criminal filing very early on in the case, or addresses that issue very early on, so you're not having to contend with the uglier and less defensible aspects of a criminal case as it sort of avalanches forward. Anyway, that was today's topic. As always, we are available. You just go to our website, CoimbraLaw.com, CoimbraLaw.com, and you can contact us through the website if you or a loved one has a criminal case and you're dealing with any sort of criminal situation, whether it's a small misdemeanor all the way to a felony crime to something that's a capital offense. We are amply equipped to handle a situation like that. I've won a multitude of awards for the great work that I've done, that my firm has put out in the defense of freedom for our clients. Thanks.